litigation and collection weapons in California that can be used by lenders, certified development corporations, and the Small Business Administration involving a Small Business Administration loan default. The major concern facing 7(a) lenders, certified development corporations, CDCS, or the Small Business Administration is whether the Small Business Administration guarantor possesses any reachable assets to satisfy a money judgment, and whether the assets will be available if a judgment is secured through litigation. The writ of attachment is a powerful tool to secure property of the guarantor at the beginning of a litigation case to satisfy a money judgment in a breach of guarantee action. What is an attachment? Attachment is a provisional remedy, obtained before an actual court judgment is rendered and even before trial, intended to secure assets to satisfy a future court judgment. Restrictions. Pre-judgment attachments are generally available in civil actions involving claims for money. However, there are 4 restrictions on the kinds of actions in which attachment is authorized. Nakasone v. Randall. Citations omitted. First, the claim must be based on an expressed or implied contract. C.C.P. paragraph 483.010a. Second, the total amount at issue must be a fixed or readily ascertainable amount of $500 or more, which may include costs and fees. C.C.P. paragraph 483.010a. Third, the claim must not be secured or, if it is secured, the security must have no value or value that is less than the amount of the claim. C.C.P. paragraph 483.010b. Fourth, if the action is against a person, an attachment may be issued only on a debt which arises out of a trade, business or profession. C.C.P. paragraph 483.010c. 492.010a. The burden is on the 7(a) lender, CDC or the Small Business Administration to prove that it has a right to attach the SBA guarantor's assets according to the statutory requirements listed above and that the claim is probably valid. C.C.P. paragraph 484.090. Validity of attachments. The need for the strict statutory requirements is due to the constitutional attack on the validity of pretrial attachment orders. In 1969, the U.S. Supreme Court held that attachment orders, pretrial wage garnishments in particular, are a violation of constitutional due process when property is taken or secured without prior notice and a hearing, except in extraordinary circumstances. Sneatic v. Family Finance Corporation of Bayview. Citations omitted. In 1971, the California Supreme Court decided in a similar fashion by holding that pretrial attachments of bank account, without due process of law, are an unconstitutional deprivation of property. Ramden v. Appellate Department. Citations omitted. Since then, California has amended existing pretrial attachment statutes to protect an individual's rights to property while also protecting the individual's rights to secure property to satisfy an eventual judgment. What can be attached? Property is defined by the California attachment statutes to include both real and personal property or any interest in either. C.C.P. paragraph 481.195. Personal property may be tangible or intangible, including money, chattel paper, documents of title, instruments, securities and general intangibles, as well as equipment, inventory and accounts receivable. C.C.P. paragraph 481.020-481.225. The most common asset that the Small Business Administration, 7(a) lender or CDC would seek to attach is the Small Business Administration guarantor's personal residence, especially if the home was not directly pledged as collateral for the Small Business Administration loan during the initial loan application process. Individuals in California. The list of attachable property owned by an individual is defined by statute. C.C.P. paragraph 487.010. California also provides a list of property exempt from attachment, which includes any property that is exempt from enforcement of a money judgment, property necessary to support debtor and his or her family, earnings, and all property not defined by statute to be attachable. C.C.P. paragraph 487.020. A debtor may claim that his or her property is exempt by statute, and a granting or denial of an exemption claim is subject to appeal. C.C.P. paragraph 703.600. Business entities. When the Small Business Administration debtor is an entity, such as a corporation, partnership, or association, all property held by the entity is available to attach by the Small Business Administration. 7. A lender or CDC. C.C.P. Paragraph 487.010. Procedure to attach property. In order to attach the Small Business Administration debtor's property, the Small Business Administration. 7. A lender or CDC must obtain a right to attach order and a writ of attachment, both applied for in a single form. C.C.P. Paragraph 484.010. A right to attach order is provided if the claim can support the issuance of a writ of attachment, and a writ of attachment will not be issued unless the court determines that the property to be attached is not exempt. C.C.P. Paragraph 487.010-484.110. After issuance of the right to attach order, the creditor can obtain writs for attachment of other additional property, as long as that property is not exempt. C.C.P. Paragraph 487.310-484.370. Two methods are available to obtain a right to attach order. Noticed hearing procedure. The most common method to obtain a right to attach order is by a noticed hearing method. The notice of hearing and application for a writ of attachment must be served on the Small Business Administration debtor at least 16 days before the date set for the hearing, and the Small Business Administration debtor's notice of opposition must be filed and served at least 5 days before the hearing. C.C.P. Paragraph 484.020-484.060. Ex parte procedure. The second method is by an ex parte application for a right to attach order or for a temporary protective order. If the Small Business Administration, 7, a lender or CDC shows that it will suffer great or irreparable injury by the delay of the issuance of the writ of attachment until after a noticed hearing, a writ may be issued based on an ex parte application. C.C.P. Paragraph 485.010a. In ex parte procedures, the creditor is only required to give a one-court day notice prior to the presentation of an ex parte application, substantially shorter than the 16-day notice for the noticed hearing procedure. CRC 3.1203a. Great or irreparable injury can be shown if there is a danger that the property to be attached may be concealed, substantially impaired in value, or made unavailable to the levy of an attachment. C.C.P. Paragraph 485.010b1. Great or irreparable injury can also be shown if the Small Business Administration debtor is insolvent to the extent that he or she is past due on his or her debts. C.C.P. Paragraph 485.010b2. Probable validity. In either method to obtain a right to attach order, the Small Business Administration, 7, a lender or CDC must prove by affidavits the probable validity of their claim. C.C.P. Paragraph 483.030. Attachment bond. Before the SBA, 7, a lender or CDC is granted a right to attach order, it must file an undertaking or a bond in a sufficient amount that would protect the SBA debtor should damages arise from a wrongful attachment. C.C.P. Paragraph 489.210. Right to attach orders require a bond, and, if the bond is not filed when the writ of attachment is granted, the writ is invalid. Verschbo v. Reiner, citations omitted. The undertaking must be in the minimum amount of $10,000, which may be increased by the court if the Small Business Administration debtor can show that the damages for wrongful attachment would exceed this amount. C.C.P. Paragraph 489.220. Also, when the Small Business Administration, 7, a lender or CDC serves the notice of attachment to the SBA debtor, it must also disclose the Small Business Administration debtor's right to object to the undertaking. C.C.P. Paragraph 489.230. And Small Business Administration debtor may take advantage of an undertaking by filing one to obtain the release of an attached property. Upon the issuance of a writ of attachment, a debtor may move the court to substitute the bond for the property that had been attached. C.C.P. Paragraph 489.310a. Temporary protective orders. The Small Business Administration, 7, a lender or CTC, which had filed an application for a right to attach order and a writ of attachment through the noticed hearing procedure may also simultaneously apply for a temporary protective order, which places an immediate lien on the property described on the order for 40 days, at which point the order expires or merges into a subsequent attachment order. C.C.P. Paragraph 486.050-486.100. If the Small Business Administration, 7A lender or CDC pursues the ex parte procedure, the court has discretion to deny the ex parte request and convert the procedure to a noticed hearing procedure and issue a temporary protective order. C.C.P. Paragraph 486.010, 486.030. Similar to attachment procedures, the Small Business Administration, 7A lender or CDC would have to file affidavits in support of the court granting a temporary protective order on the Small Business Administration debtor's property. Conclusion: for collection of Small Business Administration debts, there is no more effective tool to secure payment than a writ of attachment. In an appropriate case, attachment can literally save the Small Business Administration debt from becoming uncollectible by requiring prompt payment before an Small Business Administration debtor goes out of business or files for bankruptcy. If you defaulted on a Small Business Administration loan and believe that your personal residence or personal property may be a target for litigation in state superior or federal district court in California by the Small Business Administration, 7A lender or CDC through a writ of attachment or temporary protective order, you should speak to one of the firm attorneys by calling 1-888-756-9960 or arrange for a free case evaluation by entering your contact information.